May it please your lordship. May it please your lordship. May it please your lordship.
For the petitioner, arbitration application.
Notice. What you have in the smartphone, you have got arbitration application.
Arbitration, application.
You are looking at your phone, right?
I'm sorry.
Urgent message, right?
No, I was looking at the file.
No, you looked at the mobile phone.
My apologies for that, the file.
We thought that you have arbitration application in the smartphone, so you are opening and telling us. Don't do it, Mr. That if we have permitted, it's on account of technical reasons that technology is advanced. That doesn't mean that while appearing also you will look at the smartphone.
I fill your punch.
225 notice. Both notice 224, 225. Personal notice, whatever you write, proof of service.
Right.
Yes. Notice. Proof. Notice. Personal notice, proof of service. Notice.
Please, fresh
Notice.
personal notice being completed.
Personal notice. All cases, personal notice,
Request
proof of service.
any specific date.
You first serve and get it. It will be listed.
Right.
Yes. Yes.
I'm appearing for the respondent, not serve the papers. We were not served with the papers.
Not served, then how are you appearing?
We filed the wakalatnama, but we didn't receive the paper.
You have not been served.
No.
With the notice.
Notice we've given. I'll serve upon them, my lords. It's for appointment of an arbitrator, my lords.
Well, that's what we know about. Like that's why I'm sitting.
I'll have it served, my lords.
But how they have been served? Not served. It's a proof of service not filed. That's why he is undertaking. Counsel for the petitioner undertakes to supply copy of petition or
In 2 weeks. In 2 weeks, my lords.
not something like in German. We said.
Right back.
What did he? You are not present, right? Alive to this situation. What did he say? We asked him.
I was opening up product.
That's why same thing. Mobile and this.
My lord, the calendar is stored over here, so I was just opening a calendar back. Oblige.
Yes.
So the counter copy, my lords. Next
week
it will be posted.
Nothing what's up.
Arbitration application can be allowed.
Allow. Yes. What? What is there in this, Mister? You keep on like trying it like a civil suit for 15 years. It must remain pending, right? That's the object. Yes. This by this in this how much is what is the quantum?
It will be over 1 crore. Over 1 crore.
What is the nature of dispute?
That's specific performance by both the parties. He'll be saying specific performance of cancellation date. I'll be saying specific performance of the development agreement. There'll be claim and counterclaim by both the parties.
Mr. Justice Chala Kodandaram. Yes. Yes.
I appeal for the respondent in this matter. I request 3 days to file counter, my lord.
What counter? You can file later on, but what is there? Arbitration clause is there?
Pre-arbitral steps have not been complied with.
Huh?
Pre-arbitral steps have not been complied with.
What notice not sent?
Conciliation. According to the arbitration clause, negotiations have to be undertaken between the parties, my lord. That has not been undertaken. We'll place it on record, my lord. The counter.
Learned counsel for respondent praise friend is granted 3 days time to.
Wait, Your Lordship. This is regarding the maintainability, my Lordship.
Maintainability.
Maintainability in the
You are
arbitration.
for the petitioner.
I am for
And you are raising the question.
No, my Lordship. They raised last time that it's about maintainability. Lordship, on maintainability, my senior will come and argue by next.
No, nothing. You are the senior counsel. Yes.
Lordship, only on the maintainability.
Yes.
I have no objection.
No. You may not have. We have objection because I am a party, right, to
Yes.
the arbitration agreement. So therefore, I have problem in adjourning the case. You don't have any problem. You can. It remain pending for 20 years for you. You don't
No.
have any problem.
Not
This thing.
not
So what maintainability?
Yes, my lords, I can commence my submissions on maintainability. My
Huh?
lords, lordships, I filed a memo,
Ah,
my lordship, in arbitration application number 91 of 2020.
what like memo means like it is more than an arbitration application.
My lords,
This is memo.
in fact, we have annexed copies of various orders, my lords, which are relevant to this case, my lords. Your lordships may see page 7.
What is it, Mr.? What is page 7, page 41, page 50?
No, I apologize.
No, you are, Mr. Always remember, you are appearing here to assist us.
Yes.
The court should be, you should be able to tell the point without looking at the file. If you are not, you are doing page 7, page 43 means you are preparing the case here only.
No, my lords.
What is the big deal in a petition under 11.6?
Yes, my lord.
What is the objection? One sentence, if you are unable to state, that means your objection is not valid.
No, my lords, may allow me to submit.
Like
The rest-
you have filed this thing, these many pages, and nothing.
No, my lord,
Rightly,
No, your lordship, allow
Therefore,
me to
he-
submit briefly,
he-
my lords.
yes, praise for adjournment. Mr. Next date, we will decide, even if it doesn't. This is,
No,
advocacy is about art of brevity. And isn't such, without opening, you are saying page 7, page 43, page 53, 216. What is,
No.
simply you should be with, close the file. Learn to rely on your memory and it will never fail you. This is what, you are a young person, you are like filing 216 pages and telling the court to look at page 7. You should, without looking at the file, you should clearly tell, this is my objection to, on this ground, 1, 2. That's the end of the matter.
In fact, my lords, on page
This is what-
is one paragraph, my lords. It's the operative portion.
13th October, it is made. You are a senior counsel. So you tell your senior that I am now a senior counsel. So I will argue. Right? Okay.
Obliged.
230.
233 and 234 are also connected.
Unable to tell what is the objection, right? Page 7. Right.
No, my lords, page
Fine.
contains one paragraph,
Fine.
my lords. If your lordship.
We still not got it. You have not told what is the objection to the mental.
Moratorium order passed by the National
It's simple,
Company Law
right?
Tribunal.
So
My lords,
simple.
but- Yes, my lords. However, my lords, unlike the insolvency and bankruptcy court,
Right.
this is an order passed under the Companies Act, which is why.
Yes.
We have responded. File counter, my lord.
Huh?
We already filed counter, my lord.
What is it?
Request next, take up matter next week, my lord.
Huh?
Request to take up the matter next week.
No, nothing. No next week. What is it? What is the when is the arbitration? When is the agreement executed?
Not
Agreement.
petition is. I'm for the response, my lord,
You
already.
don't know.
The-
Who respondent that doesn't court cannot
No,
put
the-
any question. Fine.
Actually, the
Fine,
list
fine.
of the petition is for the payment of the security deposit, my lord.
1 minute. 1 minute. The court should not put any question to you because you are respondent, right?
Not like-
We will decide it. Decide. Don't worry. I wish all these facilities were available when I was practicing. I would have never become a judge. That you, when the question is put, you say, I am appearing for respondent. So
Apologies.
therefore, it means that you cannot ask any question to me because I am appearing for respondent.
I apologize, my lord. Actually, it's article and marketing agreement, my lord, dated 10 July 2015. Page number.
Which is the
60
clause, the arbitration clause.
Page number 66 of the petition application, my lord.
Yes, 20.3.
20.2 arbitration clause.
So what is, how much is the quantum of this thing
My
amount?
lord, actually, its principal is 50 lakhs and interest they claimed around 24 lakhs. Actually, the amount was repaid to him.
That we can't
in excess
decide.
amount.
That we can't decide that he should pay further amount to you. Huh? Along with
Already
the
amount
interest.
was paid, my lord. That is the only contention. What he is claiming to, he already received the amounts. We have filed along with the transaction details in our counter. This is the reason I think.
In an 11.6 petition, we should dismiss this petition by passing a money decree against him, saying that this thing he should pay you the amount, right?
No,
That's
we are
what
not
you are
claiming any amount from him, my lord. Page number 12 in our counter affidavit, we have
One
filed the
minute.
details.
This petition under 11.6 of the arbitration conciliation.
Change the note.
Yes.
My lord, the respondent filed a counter.
Ah.
They admit the arbitration clause, my lord, clause 45. But what they say is, my lord, that clause incorporates some procedure to be followed by parties. We did not follow that procedure, so the application is premature, but that's a defense taken by them. My lord, we have issued notice in the month of March 2023, my lord, demanding the amount due from them. And also we indicated that, I mean, in case they don't pay it, my lord, I mean, they'll be going for arbitration. My lord, they did not respond. They received that notice and they did not respond to it. After 3 months have passed, my lord, I mean, we filed the present application. Kindly say,
Procedure prescribed
my
page,
lord, kindly say the counter filed by them, page 4 of the counter.
no, wait, the arbitration clause,
Yes, the clause is extracted, my lord, at page 4,
page,
4 of the counter.
item 4 of the counter. Yes.
Paragraph 5.
Yes.
Hello. Each 25(1) of the purchase order, which is extracted, each party shall designate in writing to the other party a representative who shall be authorized to resolve any disorder, dispute, controversy, or claim arising under this order in an equitable manner, and unless otherwise provided herein, to exercise the authority of the party to make decisions by order. If the designated representatives are unable to resolve any such disorder, dispute, controversy, or claim within 10 days, such dispute shall be referred by such representatives to a senior officer designated by purchaser and a senior officer designated by supplier, respectively, who shall attempt to resolve the dispute within a period of 7 days. The parties agree to use their best effort to attempt to resolve all dispute, disorders, controversies, or claims arising hereunder promptly, equitably, and in good faith, and further agree to provide in a timely manner each other with reasonable non-privileged records, information, and data pertaining to any such disorder, dispute, controversy, or claim. When a party has determined it has exhausted opportunities to settle any such disorder, dispute, controversy, or claim in accordance with the clause 25(1)(a),
All right.
it must be
So what is the, how much is the amount?
more than 2 crore rupees.
Yes, madam. Whom?
My lord, page 33, my lord. The informal dispute resolution, my lord.
Ah, that we haven't.
According to that clause, we have invoked this, my lord. In the counter, the same has been extracted, my lord. The work
We'll
has been,
appoint Mr. Justice Rajshekar Reddy. Yes. Mark the presence in this petition under section 11 within bracket 6 of
Please, my lord.
Yes.
But this is an application under section 11(6) for appointment of an arbitrator. But there was a leave and license agreement entered into
Who
between the
appears?
parties.
Who appears for respondent?
Counsel also filed, my lord. I have also filed the
File.
I beg to represent, my lord, the respondents in the present case.
Ah.
I'm actually unwell with a very bad throat, a continuous cough. May I request the matter to be taken up
13th.
week, as I'm ready to argue the matter. It's only a week that I'm seeking. my lord.
Learned counsel for respondent prays for adjournment on the ground that appears through video conferencing it submit prays for adjournment on the ground that he is unwell list on 13/10/23.
Deeply obliged, my lord.
If your lordship. My lord, I'm to the petition, my lord, the petitioner is hearing with the supplier of service. The agreement was
What is appearing? What? Counter has been filed.
filed. In fact, we had issued the notice and then they also had replied notice. The dispute was regarding the arbitrators. We didn't accept their arbitrator, they didn't accept our arbitrator. My lord, that's why we filed an application.
So what is the agreement?
Distributorship agreement. Dated 21.
Distributorship agreement
Yes, my lord. He was a distributor for my goods manufactured by me, dyes and chemicals. Dated 17 December 21.
17 December 21.
And the
Which clause?
32, my lord.
Page.
Page number 35.
So when did you send the notice?
Notice was sent on 7th March 23.
7th March 23. Did not reply.
He replied, my lord, on 5th April 23.
What is?
He's proposed two other names of the arbitrators, which is not acceptable to us. Therefore, we filed this application.
This matter for the respondent, your lordship.
You first finish reading the messages on your mobile, then if you have time left and if time permits, we will hear you. No, you are looking at this thing, Mr. This is too much. We permit mobile phones inside the courtroom. Doesn't mean that you will walk in when the case is being heard, look at your mobile standing here, and then if nothing.
I am checking the list, your lordship.
No, nothing. No adjournment.
Your lordship.
Nothing.
Either pass or your lordship.
No. So what is the quantum of the amount in
The
what?
principal amount balance 57 lakhs, the interest comes to 33 lakhs, of less than a crore, just under a crore. Right.
So we'll appoint some district judge.
Yes, ma'am.
Lordship, kindly pass or your lordship.
Nothing.
No, your lordship, senior.
No. You have not come here to interrupt the proceeding of the court. You appear here. Sit down, mister.
No, your lordship.
Sit down.
29th court.
Sit down. You don't understand English? Which is? This application under section 11 within bracket 6
I appear for the respondent, Your Lordship. I have no objection with the appointment of the arbitrator.
This petition, yes,
If Your Lordship,
like former judge of this court or,
this court, Your Lordship.
all right. What is the agreement? This petition has been filed so and so, the, it- October 2023. Yes.
Obliged, right.
I appear for the applicant, Your Lordship.
Hmm.
Dispute arising out of a development agreement.
Hmm.
The arbitration clause is at page,
Nobody is appearing. Madam C, served.
it is served, Your Lordship, and
Proof of service you have filed.
there's a respondent has already appeared, Your Lordship, and count. Wakalat is already filed. Wakalat is already filed by the respondent.
My lord,
Ah.
I'm appearing for the respondent counsel,
Yes.
my lord. We have to file counter, my lord.
What counter? Not necessary.
2 weeks.
MOU dated 12/12/2022 contains an arbitration clause or not? Huh?
Only
Contains
2 weeks time, my lord. to
Why?
Counter. Right.
like written statement every case, right? As soon as plaint is filed, thereafter we will frame issues, then you will get 15 adjournment for reducing evidence, then he will seek time to reduce his evidence, then you will file documents that will be rejected, then 227 stay of proceeding for 5 years in civil suit. Like this, what? All this is, madam, you have to give up this sort of an approach. Absolutely. But everything is not to be opposed because you are appearing. Like this is all, why? This all is meant to, this alternative dispute resolution method. That too also you are converting into adversarial litigation by asking why
File.
next week.
2 weeks.
Learned counsel write her name. Respondent prays for accommodation to enable her to file counter.
Minutes, I am appearing for the applicant in this matter, my lord. The purchase order has been issued.
Huh?
Milords, I am for the respondent
the
was
applicant
requesting
is
time for filing counter. in this
Why?
matter. Because, the dispute is of 2016 and earlier notice was issued in 2018, Milords. So, time barred case and wherein civil suit is also pending in Rajasthan, Junjunu. And 138 complete is pending. There is no dispute with regard to the.
So how much time? 1 week?
My lord,
Milords,
not by
yeah, I
invitation,
need to
and
get
also
signatures, 2 weeks, Milords.
So let him file counter.
Yes.
We'll take it up 20th October. Learned counsel for respondent prays for is granted 2 weeks time to enable him to file.
the Act. I'll just pass on a brief chronology of the events that have
Not
taken
like
place.
it's a contested matter?
Yes, I'm contesting.
Oh.
I'll give reasons.
Yes, no, you sat down from that, we inferred that otherwise you would have stood up.
Yes.
So, no,
They only-
nothing, I just wanted to know, yes.
In the counter, they only want the same arbitrator to continue.
Ah.
An arbitrator who never evinced interest in the matter. I'll just give the dates.
Yes, yes.
Lakshmi, kindly consider these dates.
Hmm.
Then on 2nd November 2018, Honorable Justice so-and-so was appointed as arbitrator. Then will it Lakshmi straight away go to February 19 after this. From November 18 by February 19, filing of all pleadings including rejoinders were completed. Then will it by November 19, recording of evidence was completed, 5 witnesses in all. Then will it parties by consent extended the tenure of the arbitral tribunals. That is 1 year period was over by then. Then will it the counsel for claimant commenced his oral submissions in December 2019. Then will it in March 2020 the COVID commenced and nothing could progress further. Though the learned arbitrator gave a schedule for hearing of the counsel from on all sides, but that schedule could not be adhered to because of the intervention of COVID. Then in normal courts by July 2020, the period was over. Then we were expect and the last
July 20.
July 2020, 1.5 year period was over. That was during the COVID period. But Lordship knows that the Honorable Supreme Court extended this tenure by February 28. And during the midst of the COVID period, the last communication we received from the learned arbitrator was on 8th November 2020, the last date in that list. That was the last communication received in November 2020. After 2022, after the Supreme Court judgment, at least we expected the learned arbitrator to take the initiative to recommence the proceedings and proceed further with the matter. He does not evince any interest. The claimants tried their best, but nothing could materialize and nothing has happened. So we paid, both the parties together have paid about 60 lakhs so far as arbitrator's fee out of total fixed was about 66 lakhs. Then there are about 20 hearings which have taken place. Every hearing, both the parties together paid 1 lakh rupees towards expenses, to and fro travel expenses and other expenses. Well, all this is apart. What we are more concerned is that the arbitrator is not evincing interest in the matter after the COVID period till date. He doesn't send us any communication, not take the initiative. That's the reason we feel that by operation of this provision, all that we want is a substitute arbitrator to be appointed because it's at a stage of final hearing. Entire record is on place. Nothing
Which
should be done.
provision? Section?
Section 29A. Can you see section 29A for a moment?
Yes.
But we may straight away go to the A1, 2 minute, they describe the 1 year period and 6 months period extension. I'm sorry.
Yes.
That may take you through the entire provision. It's a very long provision. The award in matters other than international commercial arbitration shall be made by the arbitral tribunal within a period of 12 months from the date of completion of pleadings under subsection 4 of section 23. This is amended in 2019. Earlier, it was not with reference to completion of pleadings. Then, provided that the award in the matter of international commercial arbitration, we are not considered with the consent with this minute, can we go to 2 minutes? If the award is made within a period of 6 months from the date of the arbitral tribunal enters upon the reference, the arbitral tribunal shall be entitled to receive such amount as additional fee as the parties may agree. 3. The parties may by consent extend the period specified in subsection 1 for making the award for a further period not exceeding 6 months. That would take us to 1.5 years. Initial 1 year, then 6 months. Then 4 is the most crucial clause here. If the award is not made within a period specified in subsection 1 or extended period specified in subsection 3, the mandate of the arbitrator shall terminate unless the court has either prior or after the expiry of the period so specified extend the period. Provided that while extending the period under this subsection, if the court finds that the proceedings have been delayed for reasons attributable to the arbitral tribunal, then it may order reduction of fee of the arbitrator by not exceeding 5% for each month of such delay. But here in this case, though the period expired by July 2020, after the COVID period also, both the parties have not evinced interest to file an application for extension. They could have done it even after expiry of the period because the way the learned arbitrator was not evincing interest, parties have also lost their hope that anything would happen. So neither of the parties went to civil court seeking extension. That is the state of affairs today. Then my lord, LC 5. The extension of period referred to in subsection 4 may be on the application of any of the parties and may be granted only for sufficient cause and on such terms and conditions as may be imposed by the court. But this would arise only if the parties had approached the court concerned. That has not happened. While extending the period referred to in subsection 4, it shall be open to the court to substitute one or all the arbitrators, and if one or all the arbitrators are substituted, the arbitral proceedings shall continue from the stage already reached on the basis of the evidence and material already on record, and the arbitrators appointed under this section shall be deemed to have received the said evidence and material. Similarly, if your lordships proceed now to appoint substitute arbitrator, the proceedings will commence from the stage where it was left on the previous occasion. But in this particular case, we were very keen to conclude the proceedings. Even the counsel for the claimant partly made his oral submissions, final oral submissions. So that was way back in February 2020. After that, the entire thing remains standstill. But all that we want is a new arbitrator to be appointed, substitute arbitrator, so that within a short span, the whole proceeding can be concluded. This is the limited area that such.
Milord, I have two submissions to make for your lordship. There are two sections. Apart from 29A, section 15 also has a name. Kindly have a look at section 15. Milord, this is termination of the mandate and substitution of arbitrator. If your lordship kindly looks at clauses A and B of subsection 1 of 15, where he withdraws from office for any reason, or by or pursuant to agreement of the parties, the mandate of the arbitral tribunal is terminated. So in these circumstances, under subsection 2, as a matter of course, your lordship would be appointing a substitute arbitrator. Because in either event, either A or B, it's because of the parties' understanding or the arbitrator himself withdrawing. There is some sort of an indication that the arbitrator is lax in proceeding. Now, if your lordship kindly comes to section 29A, and also please look at the circumstances of this particular case. Admittedly, my lord, July 20, if your lordship kindly takes that list of dates. Admittedly, July 20, the mandate of the arbitral tribunal stood terminated. The language of 29A is the mandate shall stand terminated. And in this particular case, in the absence of an extension contemplated at the 29A4, the mandate has stood terminated. And thereafter, in a very leisurely manner, the applicant has moved your lordship only in the month of July 2023. The application is, I believe, signed on in somewhere in July 2023. So even if we were to reckon from 28th of February 2022, when the Supreme Court's order came to an end, and also keep in mind that there was 4 months residual period which was available out of the 18 months when the COVID commenced. This application comes after a lapse of 1 year. And the courts have now held that the entire intention of 29A is for the purposes of ensuring that these proceedings are concluded at the earliest point of time. It is so easy for parties to throw blame on an arbitrator who is not before your lordship and will not say that it is the arbitrator who is at fault. Now, if I were to ask this question to myself, what was the petitioner doing for 12 or 13 months after the mandate stood terminated, and where is the letter even written by them for the learned arbitrator to take up the matter? And apart from that, if your lordship kindly looks at the pleading, they also refer to another communication from the learned arbitrator, page 16, there is a reference to that. So there is nothing which is attributable on record to the arbitrator, because it would be unfair in my respectful submission for a person who is not before the court, for us to merely make the allegations orally and request your lordship to appoint another arbitrator.
What is your stand on this?
My stand is twofold. Number one, under 29A4, the application should have come prior to the termination of the mandate. Because once the mandate is terminated, it is by operation of law. Your Lordship may kindly have a look at the languages of subsection 4 of section 29. If the award is not made within the period specified in subsection 1 or the extended period under subsection 3, in this case, there was an extension of 6 months, 1 year plus 6 months, totally 1.5 years. The mandate of the arbitrator shall terminate unless the court has either prior to or after the expiry of the period so specified extended the period. Now, even for this, the applicant should have come with all reasonable dispatch and not after a lapse of 1 year. And therefore, his application for extension itself is belated, and this defeats the very objective of section 29A is my first submission. In the alternative, the casual request for substitution of an arbitrator, unlike section 15 where it follows as a matter of course, but 29A, it is of course your Lordship's discretion. But then there should be some reasonable cause for your Lordship to say why this learned arbitrator's mandate should not be extended. So, in sum, what I would say is, your Lordship may kindly consider dismissing the application as hopelessly barred and contrary to the letter and spirit of section 29A of the Arbitration Act. In the alternative, if your Lordship concludes that there is a quick case for continuation of the arbitration, my respectful submission, the substitution may not be ordered. And if your Lordship also kindly see the proviso to subsection 4, it even contemplates if the error is on the part of the arbitrator. It even contemplates reduction of his fees. So this is almost a punitive measure, which means that your Lordship will have to give a finding to the effect that the fault lies with the arbitrator. Please have a look at the proviso under 29A4.
No, extending the period.
No, 29A4.
This extension of mandate does not arise because that has to be extended before it expires. So the question of extension does not arise.
That's my submission. That's my
right.
So,
and perhaps you are submitting that this is not a case covered under section 15. Therefore, the question of
15 is a matter of course. 15 is a matter.
So therefore,
if it is covered, my submission is.
no. First, we have got that first submission is that it is belated,
Yes.
right? And what is the second submission?
Second submission is 29A4. This application ought to have been made prior to the expiration, termination of the mandate. Your Lordship may extend it later, but the application to extend should be prior is my submission. Because otherwise, parties can come at their own leisurely pace. After what prevents this party from coming after 5 days? I question to myself.
So nothing prevents. After even 10 years also.
What would your Lordship do?
Yeah, that's a different thing.
Yes. So,
Correct.
so would your Lordship countenance a party coming
Yes.
at leisure?
Yes.
Just one additional topic.
You are appearing for?
Section 7.
I appeared for 1 and 2, my lord.
One additional submission is that
Yes.
the application itself, the prayer is not for seeking extension of the mandate of the tribunal.
No, extension can't be. Like it's substitute, yes, sir.
Substitute. But my submission is that substitution cannot be a ground without seeking extension. The substitution of an arbitrator cannot be.
No, he is not seeking extension. Like he can't.
Yes, yeah, I do.
He can't, and we cannot grant. Right. Yes. Anything?
Right, 15, I think that situation does not arise in the present case. Those two situations contemplated in 15.
Yes.
15 has no application to the.
No, what do you say with regard to this? Your belated approach.
During the COVID period, there is correspondence on record to show all the parties by consent asked the arbitrator to extend the period because we were not in a position to proceed with. After the COVID period, after the Supreme Court judgment, we expected the learned arbitrator. The last communication we received was on 18th November 2020. That is during the thick of the COVID period.
No, that is correct. What have you done thereafter?
Yes, after 22 minutes, we expected the learned arbitrator to take the initiative. The initiative should come from the learned arbitrator. We've been waiting for the learned arbitrator to take the initiative and send us a communication for hearing. We've been waiting. Right? Under 29A, after July 2020, it is not only an obligation of the applicant or the claimant. Provision 4 says that either party can make an application for extension. But both the parties have chosen to remain silent on that. They did not exercise that option. to approach the court for extension of the period of tenure. Both the parties remain silent. Both the parties are equally to be blamed for it. Both the parties did not avail that remedy. And they also have a counterclaim. That's more important. Having filed a counterclaim, they also remain silent about it. Now they come to claim us. The delay, if at all, it is applicable to both the parties equally.
Then
So
it-
therefore, Millet,
it is
in the interest of justice,
What is sauce for goose is sauce for candy.
that's what I'm saying. All that I want to say is in the interest of justice and the interest of both the parties, that the arbitration proceedings which are at the back end of the stage be continued and concluded within a short time. It can be concluded. Now entire record is on available with the arbitrator. Lakshmi kindly, your lordships are agreeing with my submissions. Lakshmi kindly make an observation that the arbitrator to be appointed would commence the proceedings from where it was stopped by the previous arbitrator.
I'll pass an order.
Yes.
It's not reserved, I'll pass an order.